First of all, I'd like to say thank you for the invitation to speak to you. It's a real pleasure. And I do have a bit of a cough and a bit of a cold, so if I do punctuate my presentation with coughing, it's not a Glaswegian point of emphasis, it's simply a cough, so my apologies. My focus really is going to look at domestic matters. The domestic litigation versus domestic arbitration. Now, I fully accept that in cross-border disputes and international trade deals and international litigation, international arbitration, there is a clear lead towards international commercial arbitration. I can see that, it's very obvious. One can, at a single stroke, get rid of, by agreement with the parties, one can get rid of issues about fora, the most convenient fora, any home field advantage, any considerations of that ilk. So really I'm looking at domestic litigation and domestic arbitration only. I also will exclude from my comments the DIFC, which has its own setup, as my colleague explained. I also would like to focus on general commercial matters rather than any ultra-specialized area. For example, the most obvious being, I think, construction disputes. The construction sector seemed very happy with the arrangements for arbitration. It makes perfect sense, and my comments aren't really concerned with that. I can see the clear need for having a specialized dispute resolution forum outside the courts. So, as professionals, when we're looking at advising clients on whether to proceed with arbitration or agree arbitration clauses or proceed with arbitration, this is standard law school stuff, I suppose, but we kind of look at these standard criteria. We've got speed, cost, confidentiality, and expertise. So the comparison really, it can be in other factors, of course, but in domestic matters, we're looking at these four key elements, I believe. Now, as professionals, when we look at these issues, we can, of course, use our professional experience, and we can look at empirical data, and we can look at the data which is available, either promulgated on the internet or promulgated by each fora. Now, as far as Dubai courts are concerned, they've actually published in 2014 rather, excuse me, a comprehensive and detailed assessment of factors including speed, not so much cost, speed. You've got from the date of filing of a case at first instance to the date of delivery of a judgment at first instance. You've got the speed of appeals, and it's all been broken down into different benches. Dubai courts are divided to different benches. You have the real estate bench, the commercial bench, the civil bench, personal status bench, labour bench, so it's broken down. And even in the commercial matters, for example, there is a breakdown between a partial jurisdiction and a full jurisdiction. For the full jurisdiction, it's a three-man bench for matters involving claim amounts over 100,000 dirhams. So what I want to focus on is commercial disputes. And you'll see here, in this little table here I've got here, the average time for judgment on full commercial cases from filing a case to the judgment is 262 days. Well, I think as a common lawyer coming from England, that's quite remarkable. The average time for judgment of all cases, the breakdown, the analysis doesn't go as far as commercial cases at Court of Appeal, but for all cases, the average time for judgment from filing at the Court of Appeal to judgment is 233 days. And you'll see the last bit, the average time for judgment for all cases from filing at the Supreme Court, which is the apex court, is 240 days. So those, for a common lawyer, an English lawyer, don't look that bad compared to your experience. You're looking at getting through your average commercial dispute in less than 2 years. that's including all levels of substantive courts. Now, as far as the arbitration award is concerned, how long does it take for an arbitration? Well, those statistics aren't available. There's no data available for that. I should make a point that the LCIA produced a study, but I believe it's called the Costs and Duration Data Study in 2015. But that didn't include a consideration of the DIFC LCIA court. So what do we look at for guidance to advise our clients about duration? Well, the Civil Code says that the parties have got to get an award within 6 months, but that's regularly extended by agreement. Probably the most worrying aspect about arbitration proceedings in Dubai is that all awards must be ratified by the court, which means that instead of taking your shiny new award from your arbitrators to an execution court, one has to go through a substantive court process, and that's called ratification or certification. And of course, that's where one comes across 3 or 4 grounds of challenge to the ratification or certification of an award. Now, it's there are 3 or 4, but they mostly relate to defects. So there's either defects in the arbitral award, defects in the tribunal, or defects in the procedure. And being any talented litigator can pick up several defects in any procedure in this part of the world reasonably easily. So the opportunity for challenging the ratification of an award is quite clear. And in my experience, that challenge process does take place, which means one has to go through the whole gamut of the Dubai court proceedings: Court of First Instance, Court of Appeal, and Court of Cassation. So when you're looking at the speed of an arbitration award, one can look at this side and then automatically look back to the litigation side to see what the true duration is. As far as costs are concerned, again, I'm not really talking about professional legal costs. I'm talking about court fees or arbitrators' fees rather than professional legal fees or party costs. The maximum filing fees in Dubai court is 40,000 dirhams, which is just over $10,000. At appeal, maximum court of appeal fee is 20,000 dirhams, which is about $6,000. And cassation is 4,000 dirhams, which is just over $1,000. So one can see that these court filing fees are relatively modest when compared to the filing fees or arbitrators' fees in arbitration. The DIAC fees, I just downloaded a schedule of fees from the internet. So we have here, certainly for the claims over 250 million, you can have a whopping million dirhams in fees, arbitrators' fees. That's the maximum, of course. So over and above your professional legal fees, one can look at having quite a substantial amount of arbitrators' fees and administration fees, which you simply don't get when you're at the courts. For a more modest commercial dispute, 250 million seems to be a sort of top-end figure. But if you've got a claim of between 5 and 10 million dirhams, which is a standard type of dispute that I come across, the admin fees 50,000 dirhams, and the arbitration fees is the minimum 47,000 and maximum 200,000 plus a percentage. So one can still see that even the more modest claim amounts can still attract quite substantial fees. As far as professional fees are concerned, it's anyone's guess what fees are for arbitrations. In the study that the LCIA produced in 2015, they had actually said that in respect of their fees and their costs, they would only equate to about 20% of the total arbitration costs. So one can then look at experts' fees, professional legal fees, comprising about 80% of the actual costs of the arbitration. Confidentiality, of course, is another important aspect to some parties, and of course arbitration is confidential. But in Dubai, court hearings and court records are not open to the public. If one strolls down to the Dubai courts and sits in a courtroom, pretty soon a court bailiff will come up and say, "What are you doing here? Do you have a power of attorney? Are you a litigant?" It's not open to the public. One has to actually be a party to proceedings. And of course, the records are not available to the public. All the court documents are not available to the public. And when the law reports are actually published, the names of the parties are actually redacted. So there is a measure of confidentiality, I think, which attracts to Dubai courts. Expertise of decision makers, I think that therein lies the crux. Parties agreeing to go to arbitration obviously feel there's the need to do so, and one of those, in my experience, is the expertise of the decision maker. Now, one of the published statistics of the Dubai court report is that 81% of full commercial judgments are actually upheld at the Court of Appeal. 9% are dismissed and 11% are amended. So I think that's a pretty good indication of the standard of Court of First Instance judges. The even more spectacular result, I believe, is that 79% of Court of Appeal judgments are upheld, and they're upheld by the Court of Cassation. One of our esteemed speakers earlier said that the courts of cassation, or the higher courts, the apex courts, generally tend to get things right. Well, I think that indicates that 80% of the time, lower courts get things right too. Of course, one noteworthy point is that in the civil law system in which Dubai operates under, the expertise of the bench doesn't necessarily have to extend as far as the subject matter of the dispute. So if a court is unhappy that it has the expertise, it can appoint an expert to look at matters of fact, and who then is effectively delegated to investigate the facts and review documents and exercise his expertise in looking at the relevant issues. And as far as the arbitration area is concerned, well, it's just freedom of choice. You pays your money and you takes your choice. And one, of course, from I think our colleague from the Netherlands pointed out that the experience of arbitrators is a movable feast. It can change. So I would also invite you to consider your own personal perceptions, professional perceptions about the expertise of decision makers. It's quite a lengthy quote, but I think it's instructive if I just read it out. It says, Middle Eastern countries are generally characterized by weak judiciaries, which are not independent from the executive branches of government. The judges in the region are often government employees working under the executive through the Minister of Justice. This gives the executive branch the power to interfere in the judicial process. And then it gives the example of Egypt and Lebanon. But it says they're often under pressure from the executive branches of their governments. Further, the judiciary in the Middle East countries is often characterized by lack of binding precedent, lack of procedural transparency, specially developed doctrines, unavailability of remedies, etc., etc. I don't know about you, but I would take issue with Mr. Michael K. Lindsay, who I understand is an American attorney. I wouldn't exactly call it anything other than perhaps he's a bit uncomfortable with jurisdictions that he's not familiar with. But I think he's taking one step too far if he blankly characterizes the judiciary of several countries in such a way. Certainly if there's empirical data about some of these thoughts, everyone would be happy to see it. But I would invite everyone sitting here just to be careful how they review these types of perceptions. Also, I believe one of the reasons why arbitration has seen a growth in Dubai is because a lot of the Dubai government entities have inserted arbitration clauses within their contracts with contractors. I call it shoehorning. It's, if anyone's unfamiliar with the idiom, it's where one uses a tool to help a perhaps oversized foot into an undersized shoe. I'm really alluding to the fact that it might not be a good fit for the particular contract or particular parties, but nevertheless there's a political or commercial imperative which is to promote the region as an arbitral hub. I'm not saying that's a bad thing. I'm just saying that sometimes it can lead to arbitration clauses being inserted when perhaps the parties, if they had a free choice, wouldn't have it. Okay. My last point is probably the more controversial, and that is, and I have had the great fortune of working for a number of different international law firms in the region, as well as a local law firm. And I can safely say that professional loss of control and/or revenue also, I think, if not explicitly but implicitly, figures into decisions about arbitration clauses or what's the more appropriate forum. Obviously, common lawyers are unhappy proceeding in a civil law jurisdiction, and that's because they don't understand civil law concepts and precepts, but that's for another discussion. So, just my concluding comments. I put here, and the winner is, what I had intended to do was ask people to raise their hands and say, what do you think is the winner? But of course, I think that's the wrong question. I think the question is the client the winner? Are the parties that we advise, our clients, are they winning when we refer them to arbitration or when we recommend arbitration or court proceedings? So my invitation to you, I suppose, my final comments would be, I would respectfully invite you to review the basis upon which you make these recommendations to clients. Of course, if the cap fits, if it's appropriate in a particular instance, by all means, insert an arbitration clause. But one shouldn't forget that the factors that clients care about, cost and speed, should also be taken into account and really not just advised upon on the basis of professional perception or, I hate to say the word prejudice, but look at empirical data which is available. And my final point is, if that empirical data isn't available, as in most cases it's not, I think it's incumbent upon the profession to make sure that the arbitral fora or the courts, we're all users of these institutions, are fully aware that there's a need for these types of publications, this type of data to be collected, collated, and disseminated. Is very important for our clients and how we all do business. And thank you for your attention.